And now invite kindly Jon Skiddu from Validity Fund, our colleague and partner organization with whom we cooperate for numerous years, to present the results of international research in the context of the European Union.
Hello, everyone. It's an enormous pleasure and honor to speak with everyone here. I would like to, first of all, thank the Ministry of Justice and the Vice Minister and the colleagues from the Ministry that agreed to host this event today. As well, I would like to thank very much our colleagues, our partners from mental health perspectives for organizing such a meaningful event and where we can speak about our findings regarding the access to justice of defendants with intellectual and psychosocial disabilities, but as well maybe to share some of our plans that we have for the Enable project and maybe the needs that need to be thought about and addressed regarding this specific group. Before starting my presentation, I would like to say, and maybe that the most important persons or actors actually that should presenting these reports are the authors. So the report that we are going to present has been developed by experienced non-government organizations and experts from 8 EU countries. So my role here would be just to eventually summarize and share with you most important findings that our partners revealed in their countries. So basically, I'm summarizing all the work has been done by partners. We just don't want to keep you here all day. So in order to make this session efficient, time efficient, and to brief you on all the findings, I'm here. But I kindly invite the partners to follow up with any info. So please feel free to come with any additional information and details that you may think are important to be mentioned. Yeah, and maybe the last thing, please, as colleagues mentioned before, don't hesitate to pose your questions. Do it here or online. Hopefully we'll find answer to your questions. If not, this means that we have additional work to do, and there is plenty of work to do in the field. So additional questions will make just only this event and this process more engaging and more interesting. Yeah. I'm here. I brought my laptop as well because I made some notes there for each presentation that might not necessarily be displayed here. Okay, so maybe just a few words about the project itself. So as my colleagues mentioned previously, this is an European Commission Fund project. It's implemented by 9 NGOs. It's a consortium which is coordinated by the Validity Foundation. The extended or the full title of the project is Enabling Access to Justice for Defendants with Intellectual and Psychosocial Disabilities. Its implementation period is 2 years. We started in September 2022, and we finish in the next August 2024. So what are the main outputs that we are delivering within the project? This is exactly what we present today. So this is the research on access to justice of this specific group in 8 EU countries. We call it participatory and inclusive research because of the reasons specified above by our colleagues above. It was a process that involved extensively various professionals from the justice sector, but as well persons with intellectual and psychosocial disabilities, and as well persons who had direct experience of being a defendant or being a party to a criminal proceeding. So the next output that we want to produce and that we are excited to tell you about, this is a disability bench book. This is basically a tool that we envisage to be useful, especially for judges, but maybe as well prosecutors, in order to apply more efficiently or apply practically the international human rights standards when it comes to procedural accommodation. So we will speak about the disability bench book within the next session. So hopefully this is going to be as well even more interesting session, which might even generate hopefully more discussions and more input from everyone's side. Other thing that we want to do within the project is build capacities of the same justice sector professionals regarding international human rights law, regarding the human rights approach to disability, regarding procedural accommodation, how it is applied in practice. Of course, this capacity building will be implemented throughout all participating countries. Also, an ambitious objective that we have is even provide even a bit more practical guidance by supporting the development of cross-disciplinary cooperation protocol. So basically, you will as well see in some of the countries there are already some promising practices of cooperation between various stakeholders in the field. So basically, we will look into them, we will see what can be improved, and we will look for maybe developing those practices even better and maybe replicating them across the consortium countries. And of course, we're going to do awareness raising for the many reasons that were specified above. So when putting together this presentation, I was asked to make it as illustrative as possible and just to, again, show experiences and speak about experiences of various actors, stakeholders that we engaged or partners engaged in during the research and maybe even field work. So some of the quotes that you hear, that you read here, they're speaking about stigma, about maybe about attitude which sees defendants with intellectual and psychosocial disabilities as persons that may be already persecuted without having a fair trial, or who are regarded already as persons eventually guilty of committing a crime. Then you will as well see in these quotes lack of experience, lack of exposure to this field, and an insufficient understanding of the disability rights field. The next quotes are as well speaking about lack of legal obligations to take into consideration special needs, lack of due diligence in professional obligations, and maybe lack of accountability. We will develop on those in the next slides. But maybe what I wanted as well to draw your attention to, and this was noted by the Mr. Vice Minister and as well Mr. Ruskus, this speaks about the vulnerability of this specific group of persons with intellectual and psychosocial disabilities. And their vulnerability we can see in many different walks or relations or different situations. But what is even more important, I think that we would rarely find a group that experience so severe human rights violations as this specific group, as, for example, as was mentioned above, deprivation of legal capacity, forced abortion, forced sterilization, non-consensual medical treatment, forced deprivation of liberty, and so on. So we are, as well, it's very important what was said, that basically a discussion on these topics show how efficient the state delivers justice services for the most vulnerable. So, and I think we can relate to what Mr. Vice Minister said, that actually universal design is approach that we as well should see in the configuration of justice services, so, and especially for a group as vulnerable as this is. Okay, so besides the things that were mentioned above, like why did we choose this topic? So, and as we learned from the field work that we've done, we noted there is a very interesting, I think, provision in most of the criminal proceeding codes in most of our countries that says the following. So, and I think this is even in the first or the second article of the criminal proceeding codes usually. So the purpose of the criminal process is to protect the person, society, and the state from crime, as well as to protect the person and society from wrongdoings by persons in position of power in their work related to the investigation of alleged or committed crimes. Most important, so that any person who has committed a crime is punished according to his guilt, and no innocent person is held criminally responsible and convicted. So we basically speak about this topic because we see that this principle is not actually working for this specific group, and that the safeguards that are put in place in our criminal procedural legislation are actually not necessarily applicable to defendants with intellectual and psychosocial disabilities. So ensuring protection of defendants' rights throughout their entire criminal process and a fair trial is also part of the state's duties vis-a-vis its citizens and the society as a whole. So what are some of those safeguards that we are speaking about? This is something that we discussed already here, and we're continuing, and we will keep discussing about that. This is the right to be provided with information about the rights, the right to be provided with interpretation and translation during proceedings, the right to have access to a lawyer and to free legal aid, the right to be presumed innocent until proven guilty under the law, and the right to be present in person at the trial. So maybe what is as well important to mention here, before going to the next slide, that defendants with disabilities, similarly to other vulnerable groups, need procedural adjustments, accommodations, to enable them to use these rights and safeguards. Basically, accommodating these safeguards to specific needs is not something that is new for many of our jurisdictions. We know that these accommodations occur very often in criminal proceedings that involve minors. So we have persons that support the communication. Then we as well have special procedure when it comes to the questioning, or maybe when the interrogation of minor takes place, we have special rooms. Usually we have special people that provide sort of interpretation or that bridge the very complicated procedural communication or language between judges, prosecutors, and this specific group. So, let's look at the other example. Other example is victims of domestic violence. Usually, to protect them from re-victimization, there are made different procedural accommodations just to make sure that persons, when going through the criminal proceedings, they are not being victimized, or they are not exposed to sufferings, or the process goes taking into account their human dignity. So this is not a new element. This is not a new thing. This is just seeing special needs as a core accommodation of those special needs as a core obligation, as it actually specified in the international human rights law. And this is something that all our states in the EU and not only have committed to. So let's go forward with maybe speaking about a bit about or specifying a bit about the research. So the what, where, and how. So already, as Gabriele mentioned, so we look into the national partners. Look, this is the most important. I am just summarizing. So, so partners look into their national legal and political framework about access to justice to defendants with disabilities, mainly focusing on reasonable and procedural accommodations. So partners look into the experiences of various stakeholders, as specified above. So criminal justice sector professional, but as well defendants with disabilities. We partners as well talked with national human rights institution representatives, with NGO representatives, with organizations of persons with disabilities. So this was like a very engaging and we think a very thorough dialogue with various stakeholders. And as well, partners look into the promising practices of promoting inclusion and access to justice to defendants in their countries. And we're going to speak about that a bit further. So again, the countries that participated are Romania, Portugal, Czechia, Bulgaria, Slovenia, Slovakia, Spain, and Lithuania. So quite a few countries and quite a few findings there. Yeah, just the main findings. What we learned, and this may not come as a surprise for most of us, is actually there are commitments in place to ensure that the rights of persons with intellectual and psychosocial disabilities are respected. So, and as well as has been mentioned above, that substantive equality principles are put in place in order to ensure that everyone has access to justice, and the CRPD has been ratified without no reservations or objections by all countries that participated in the evaluation. At the same time, the UN Committee on Rights of Persons with Disabilities noted for each of this country basically few findings that are speaking about the need to review laws and abolish practices that allow deprivation of legal capacities of persons with intellectual and psychosocial disabilities. They need to ensure procedural accommodation. They need to provide documents in accessible format and sign language interpreters, ensuring that testimony of persons with intellectual and psychosocial disabilities are not considered as lacking credibility, and provide training to the judicial personnel. So many of the things actually that we talked about so far. What partners as well noted when they looked into EU directives. So basically, they noted that they're not conducive enough to generate reforms and to ensure procedural accommodation. So one of the quotes there is that the EU directives on the right to defense include broadly worded provisions that in practice could be interpreted to provide appropriate rights protection to defendants with disabilities, but they do not include disability in their scope. So basically, when we speak about directives, we speak the directive on the right to interpretation, right to information, of access to a lawyer, right to legal aid, and on strengthening of certain aspects of presumption of innocence. But when we speak not conducive, what do we mean? Basically, we speak that most of those directives in one way or another address the special needs of person with disabilities, but they're mostly looking into the special needs of person with hearing or speech disabilities. So if we speak about interpretation in translation, we're speaking about mostly accommodations that actually respond to that specific needs, and they don't look into the cognitive barriers of receiving information and receiving interpretation and translations. But on the other hand, if we on the directive on the right to information, so the directive as well does not require this information to be accessible for defendants with cognitive barriers. So that information, you would see that information being translated or maybe being offered in formats that are be suitable for specific barriers, um, um, which are appropriate mostly to the needs of persons with hearing and speech disabilities. So some of the systemic barriers in the national legislation. As was noted above, laws in most countries allow legal capacity deprivation. In some jurisdictions, when there are some systems to provide supported decision making instead of deprivation of legal capacity, implementation of those mechanism is still pending. So as noted above, this triggers the exclusion from the criminal proceedings and substitution of those persons by guardians in those specific trials. So insufficient measures are taken to detect intellectual disabilities. As we noted, in many countries, the fact that a person has a disability is many times identified already in detention, when persons have already went through all the criminal proceedings without any procedural accommodations. As we understand, this creates significant or poses significant questions about the fair trial that those persons received. As we'll see above, very often the special needs are perceived as maybe lack of cooperation or maybe unwilling to cooperate uh, just because of the lack of knowledge and maybe capacities um, within state institutions that are investigating or are ensuring due trial. When a forensic doctor is involved in evaluation of the person, it's usually not the person of forensic expertise is involved, not in order to see what are the special needs of the person, but mostly to declare that the person is unimputable or unimputable, and there should be applied security measures. And also, we might say about the lack of systemic approach to the situation when the special needs are being identified, because in the other instance, for example, in appeal, very often those needs are not being recorded anywhere, and the person just the information about the special needs is not anywhere. Anywhere to be found. Yeah, maybe another slide. Sorry. So again, the legal framework do not mention any situation or request or offering of procedural accommodation as been specified above. Still, many countries, after the intellectual disability is detected, persons are usually confined in forensic institution for forced treatment and security measures. Access to information and communication. Generally, I think we covered the fact that there is no obligation in criminal proceedings to adapt the language to information and to be communicated in a way which is understandable for defendants with intellectual and psychosocial disabilities. Usually, there or in all countries there is not specified the institution of an intermediary, just with some minor exceptions, but still the intermediary are not specified directly in criminal proceedings. There is no technical assisting equipment on top of that, so basically there is not only the legislation lacking, but is as well there is no infrastructure, technical infrastructure to supplement any of those needs. And maybe when some procedural accommodation is offered, this is mostly done at the, I would say, free will of justice sector professionals. So basically, when judges or prosecutors see that there is a need to provide accommodation, there is usually used a more simple language, and maybe, as they say, they just speak more slowly. Um, yeah, so discretion of the judge when procedural accommodation are done, and this is as well discretion of prosecutors, police officers. Stigma, ignorance, and prejudice. Regretfully, this is what we found, or partners found in their field works, when there is actually lack of understanding of the special needs and why do they have to provide. Very often, it's the behavior of this group is perceived either as uncooperative behavior or is uh, infantilized. Maybe as well, super important is that there is no actually statistical disaggregated data. So countries, jurisdictions usually don't know how many persons with intellectual and psycho disabilities pass through their systems. They don't know what was the reaction of the state. They don't have any disaggregated or maybe big data on what are the needs of this specific group and how the states actually uh, ensured their trial. Yeah, no cooperation, regretfully, and there are cases when very often when defendants do not manage to participate in court, especially in person. There are as well issues with access to a lawyer when um, very often lawyers meet their clients only in court. The quality of public legal assistance is significantly below the level of the private one, and the private one is not always available. Maybe if Kirili would let me maybe say a few words about recommendations. So maybe just a few. This would be like general recommendations that we can deduct from all reports. So states need to make sure that the issues or their obligations in accordance with international human rights law are on public agenda, and they're quite high up, and the commitment should be in line with the um, level of violations that those persons or person with intellectual and psychosocial disabilities experience within the criminal justice sector. Harmonization of legislation, ensuring of assisting equipment, development of effective protocols, increase interinstitutional collaboration, and provide ongoing training. What we will do next in Enable, and also this is related to the next session, we will speak about what are the practical tools that should be put in place in order to make sure that states do progress when it comes to ensuring procedural accommodation. And one of the main topics is going to be the development of model bench book for judges on providing procedural accommodation. Yeah, thank you for, I took a bit more time than expected, but yeah, there is a lot of things to say about this. And yeah, if any of the partners want to come with some additional info, please do.
We are slightly lagging behind our agenda, which only means that we're having a very interesting, challenging event. But maybe we still have time for just one question or comment. We'll have more space, more time to discuss urgent issues or after the coffee break, and if there are additional just questions coming up, we will be sure we will answer them. Welcome. Just want to ask the following: do you plan in the future to conduct a similar, let's say, study on the rights of defendants in civil proceedings? Because right now we are talking about criminal proceedings. How about civil proceedings? Thank you.
I think that this is a topic which definitely needs to be explored. In addition, I think this is a topic of interest for not only for our consortium, but a topic that is relevant for basically again for at the EU level in general and way beyond that. So we are looking into that. This is something that we don't expect to do within the project specifically, but this is something that as well needs very, very detailed attention to.
Thank you very much. Please leave all the other questions for the end of discussions.